By now, you know that I am so sick of these outdated financial hot takes. You know, the things that sound like you're not allowed to have a latte if you don't have an emergency fund, or that if you're unmarried and in a romantic relationship, you need to split everything 50-50 down the middle.
Ugh.
Hi, I'm Lindsay Bryan-Podvin, Michigan's first financial therapist, and this video is for couples who want to protect their financial well-being without a marriage certificate. Unfortunately, unmarried couples just don't get the same automatic legal protection that married couples do. If you share a home, buy property together, or are building a financially intersected life, the law won't automatically step in to sort things out if something goes wrong. The truth is, the path to marriage isn't always straightforward, and it honestly just isn't everyone's goal, nor should it be. If something terrible happens, whether it's a death, disability, or even a gnarly breakup, you want to create a plan that protects you while you're sound of mind and body and care about one another. So if you want to protect your finances and your relationship without a marriage certificate, you're exactly where you should be. Two quick notes. I'll use the word couples in this video or in this podcast for simplicity's sake, but these tips will apply to any non-married relationship. Whether you're a throuple, a polycule, or something else entirely, like cohabitating with a platonic bestie, the state already struggles to recognize unmarried partners, and it really doesn't know what to do when love or partnership doesn't fit into this neat and dated box. So that's why having clear legal protections in place is even more important. And the second thing I need to share is a legal disclaimer. I'm not a lawyer and I don't play one here. The information and content provided by me, Lindsay Bryan-Podvin, and Mind Money Balance is just for entertainment and informational purposes. It should not be considered legal or financial advice. Please seek out legal consultation for tailored information for your specific advice. All right, with those two little disclaimers out of the way, let's start with what might be the least romantic document, but one of the most important, a cohabitation agreement. And no, this is not a document where you sign on the dotted line to say whose turn it is to take out the trash or to fold laundry. Instead, this is really a prenup for unmarried couples. It outlines how you'll share ownership, manage money, or divide assets if you separate, and clarifies any other financial details that are important to your relationship. And depending on where you live, a domestic partnership agreement is another option. If your state or city recognizes a domestic partnership, I highly recommend you look into it because they tend to provide even more protection than a cohabitation agreement. They can often include things like eligibility for health or retirement benefits, or the ability to adopt a non-biological child of your partner in case they were incapacitated. So first and foremost, get yourself a cohabitation agreement or a domestic partnership agreement. Next thing is kind of an umbrella term, but it's really important to talk about and make sure that you understand what goes into it, and that is estate planning. And estate planning gets a really bad rap. Many people assume that estate planning is just for the uber wealthy, but if you're an unmarried couple, an estate plan is essential because without legal documents that go into estate planning, like a will, a healthcare proxy, a financial power of attorney, your partner could be completely left out if something happens to you, even if you've been together for years. This means that the state decides who gets a say. At worst, this might mean a family member that you're estranged from, or at best, it might be somebody that you aren't close with who is suddenly in charge of making a lot of decisions for you. So terms like will and trust are often used interchangeably, but they serve different purposes. A will outlines who gets what after you pass, while a trust helps your assets skip probate and get to the people that you want them to go to faster with fewer headaches. And depending on your situation, having both can provide clarity and protection. Quick little definition about the word probate, which I will be using a lot in this section. Probate is the legal process of overseeing how different things that a person owned or the assets that they had will get distributed or divvied up. Each state has its own laws about what goes where, and if you don't have a will, if you don't have a trust, if you don't have some of these agreements in place, then an inventory of everything that you own will go to the court, and the probate court will decide what item or what asset goes to whom. If you do not plan for something bad happening to you, then everything that you own will end up in the probate process, which is why it's so important to have an estate plan where you decide what is going to go where. Probate can be an incredibly stressful situation. It can take a long time, and it can become really contentious if you aren't clear on what you want to have happen in the event of your passing, because family members who can start pointing fingers around what they heard you say or what they think you would want to have happen. And again, if you have a partner that you are not married to, that you want to have access to some of your assets, you need to make sure that you clearly outline it so it doesn't end up all tangled up in probate. So here are some estate planning documents you'll want to consider. First is a will to decide who gets what, including making sure that your partner gets access to or inherits what it is that you intend them to inherit. The next thing is a durable power of attorney for finances. This is a document that allows somebody to step in and pay bills or manage your money in the event that you're incapacitated. After that is a healthcare proxy, and this is a similar document to the durable power of attorney for money, but instead it's about your healthcare choices. This allows a person that you deem to be in charge of being able to make medical decisions on your behalf if needed. For both the durable power of attorney for finances and the healthcare proxy, please do not just write in somebody's name and hope that they will know exactly what to do. This requires a slightly awkward conversation to let people know what's going on in your financial world and what your healthcare wishes are, so that they can make sure that you are having the things paid for that you need to be paid in the event that you are incapacitated, such as rent or premiums on healthcare insurance. And for a healthcare proxy, this makes sure that somebody else knows what you do or don't want to have done in the event that something happens to you. Again, these are slightly awkward conversations, but it's so much better to have this conversation up front than to end up in a situation where somebody says something on your behalf that you do not want to have happen to you. The next thing to check on when it comes to estate planning is making sure that you have designated a retirement account beneficiary if you're contributing to any sort of retirement plan. So whether you are contributing to a Roth IRA on your own, or whether you get something like a 401k or a 403b, make sure to click around in those settings to make sure that you have decided who will be able to have that money in the event that something happens to you. If you are not married, it will often default to whatever the state's rules are, and it might be a next of kin that you don't want getting that money. So make sure that you have your partner's name in there, or if you want to put everything into a trust, you could put your name trust. So for example, if I were to have a trust, it would say Lindsay Bryan-Podvin Trust. And in my retirement account, I would type in who is to receive it as the beneficiary as the Lindsay Bryan-Podvin Trust. So you can either put in their name, or if you have a trust set up, go ahead and put in the name of the trust in that beneficiary field. This makes sure that the person you want to get that money will be able to get that money, and it keeps it out of probate. And this isn't just about like financial protection and making sure you keep your stuff out of the court. In the event of an untimely death, it is so painful and so overwhelming just to go through the grieving process, and to layer on the administrative burdens of going through probate is just an additional headache and pain point that you can help your family and loved ones avoid by creating a will and trust. All right, next thing I want you to think about is your home or your property. If you're unmarried and you buy property together, you must clarify who owns it from the start. There are two main ways that we define ownership in the United States when it comes to partners who purchase a property together. One is joint tenants with the rights of survivorship, and this means that the property will automatically pass to whomever else is named in the event of your passing. And the other option is tenants in common. And this lets each person who owns a property leave their share to somebody else in the will. So for example, if you are cohabitating with somebody, but you are just platonic besties, like I mentioned at the start of this, you may want them to automatically inherit it, which would be the joint tenants with rights of survivorship, or you may want to pass your portion on to somebody else. Maybe you have an adult child and you want them to have access to your portion of the property that you own, then you would name them instead. So you would go into it as tenants in common, meaning you each have common access, or you have a common agreement around which the property is owned and how it will be divided. And if you pass, you can pass it on to, in this example, an adult child. If only one person's name is on the property title, you must make sure that it is intentional and not just like the default of what was easier. For example, putting the person who had a better credit score on the title. If you do that when you're purchasing it, make sure you change it as soon as possible so that you both have an agreement around what will happen to that property in case something happens. To share a little bit about my story, my partner and I bought a house before we were married, and we agreed on joint tenants with rights of survivorship, and we also had a will and trust drawn up at that same time. It might sound alarmist, but we all know that life can change in an instant, and we decided that we would rather have legal protection and legal documentation in place that we would hopefully never have to use instead of dealing with legal paperwork and emotional burden on top of a tragedy. The financial hack that I used here to make sure that we had a lawyer review our property ownership documentation and make sure that we had a will and trust that was in place was that I was traditionally employed at the time, and I was checking my benefits, and my employer at the time offered legal protection. So I was able to turn on legal protection for, I think it was a couple of dollars a month. It was definitely less than $5. I don't remember the exact amount. And I was able to turn it on, have a lawyer review our property ownership agreement, and we were able to go in and have a will and trust drawn up and reviewed and signed by a lawyer. The few dollars of turning on legal benefits protection provided us with thousands of dollars of legal support and access. So definitely double check whether or not you have access to legal benefits if you are traditionally employed. I know this sounds a little grim and maybe even over the top, but I am telling you that doing some paperwork ahead of time is so much better than trying to do paperwork in case of an emergency. And I can also say to you my personal experience of having the conversation about how we wanted the property to be passed on to one another, what we wanted to have happen to us in the event of death or disability, really opened the door to having some deep and meaningful conversations. I think for a lot of people, they worry that if they talk about the dark stuff or the hard stuff or the scary stuff, that it will somehow make their relationship dark and hard and scary. But I found the complete opposite, that having some of these heavy conversations made us feel closer together and more aligned. And, we got to know one another on an even deeper level. So I would highly recommend making sure that you have these documents in place for estate planning, especially if you own a property together. By the way, while you're here, if this information is helpful, please like and subscribe. I share new videos and podcasts like this every single month to help protect your finances, yes, but of course, making sure that you have financial peace of mind and can enjoy life outside of the dollars and cents of it all. Next thing and last thing is insurance. Insurance is so necessary and also a commonly overlooked form of financial protection. And life insurance, in my opinion, is not named really well because it's not about protecting you when you're alive. It's about protecting your loved ones in the event of your death. So life insurance is an insurance policy that is paid out in the event of your death. Much like I was talking about earlier with retirement accounts, make sure that if you have life insurance, that your beneficiaries are set up to have that money go to whoever you want it to go to. So again, it could be the name of your partner. A lot of life insurance policies will let you split it a certain percentage of ways. Like, for example, if you wanted to go to 3 different people, you can divvy it up 33% per person. Or again, if you have a will and trust, you can again have the beneficiary be to the trust itself, and it will be divvied out based on how you set up that trust. So that's life insurance. And the other type of insurance is disability insurance. Disability insurance is important across the board, but especially if one partner relies on the other one financially. For example, if you have a stay-at-home partner and they are contributing to the relationship in a different way that isn't going out and earning money, disability insurance can be just as important in life insurance because it replaces the income of the working person if something unexpected happens and leaves the person who has that disability insurance unable to work. Statistically speaking, it is far more likely for younger adults to experience a disability than an early death. Make sure you have access to disability insurance. And again, same thing as before, make sure that your beneficiary is laid out in the way that you want it to be laid out. So big exhale. We've made it to the end. And to sum it all up or to give you a takeaway, You don't have to be married to care deeply about your partner and build a life together and make sure that you are caring for one another in a way that is important in case something happens to you or to your partner. Having a few intentional documents in place, whether that's a cohabitation agreement, a will and a trust, or just even taking a few minutes to update your retirement beneficiaries, helps your relationship stay protected in the legal and financial sense. Financial health isn't just about the dollars and cents. It's about safety, clarity, and also just peace of mind, the emotional burden that can be lifted knowing that you have sat down and created these documents and made sure that they are in place to care for one another. If you found this helpful, let me know. And as always, you can like and subscribe, whether you're here on YouTube or if you want to follow it as a podcast, you can do that as well. Again, my name is Lindsay Bryan-Podvin of Mind Money Balance, and I'll see you real soon.